Mullins?
Yes.
All right, thank you. And Mr. Feigelson, if you would enter your appearance, please.
Yes, Your Honor. Good afternoon, Assistant Public Defender Stephen Feigelson on behalf of Mr. Mullins, who's present by way of video conferencing this afternoon.
All right, thank you. Mr. Mullins, this is a felony complaint indicating on or about January 24th of 2025 at 216 East Thomas Street, Lansing, Ingham County, Michigan. Sir, count one alleges that you did willfully and maliciously burn, damage, or destroy by fire or explosive personal property with a value of $1,000 or more, but less than $20,000. That is contrary to law. It is a felony, carries a maximum penalty of 5 years and or $10,000 or 3 times the value of the property damaged or destroyed, whichever is greater. Do you understand the charge and the maximum penalty, Mr. Mullins?
I understand your perspective of what occurred and outside
Well,
of that.
hang on. Before you go too far, this is just what's written on the paper. You are presumed innocent. Let me finish, okay? And you'll understand why I'm saying this. You are presumed innocent. So we want to make sure that you don't say anything today that can be used against you. So when you get to talk with your attorney in private, that's when you're going to want to talk about what happened or didn't happen. I can only tell you what the charge is and the penalty is, and then you'll talk to your attorney and they will help you prepare a defense against the charge. Does that make sense?
I'm 29 years old.
All right, then, Mr. Mullins, you understand the charge and the maximum penalty. You don't have to agree to it. You just understand. Right. Is that right?
Yeah, no disrespect.
Okay. Perfect. All right, now you do have rights as well. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one, one can be appointed for you at court expense. Additionally, you are presumed innocent, as I said earlier, and if you are found guilty, it has to be beyond a reasonable doubt. You also have the right to remain silent. Anything you say or write can be used against you, and you always have the right to have a lawyer present with you at any time that you are questioned. Do you understand those rights, Mr. Mullins?
You said read anything you say or write can be used against you? Did you say that?
Yes, I did say that. Yes, sir.
Me no speak English on that one, but everything else, yes.
Okay, good. All right, then, is he applying for an attorney today, Mr. Feigelson?
Yes, he is. He presently works with our office on another matter, Your Honor.
Okay, thank you. So, Mr. Mullins, what we're going to do is we have 2 hearings set for you on this. A probable cause conference, which is the first hearing. That is February 6th. That's at 8:30 a.m. with Judge Simmons. Excuse me. You are allowed to appear remotely on that. So that's why you will have a colored sheet. I think it's kind of a bluish green. Yep. Okay, you should have that, so you can appear February 6th at 8:30 a.m. remotely or in person. The second hearing is a preliminary exam. You have to appear in person for that. That's on the 6th floor of City Hall, Courtroom 4, and that's February 13th at 8:30 a.m., also with Judge Simmons. So you've got the notice and the Zoom instructions, correct?
Yes.
Good. Okay. Now, is there anything I've told you so far that you do not understand?
All right, buckle up, because today's courtroom lineup is absolutely unhinged. We've got multiple hearings, multiple personalities, and one defendant who seems physically incapable of shutting himself up when a judge is literally begging him to do so. This case isn't just about alleged arson, It's about entitlement, self-sabotage, and what happens when someone mistakes a courtroom for an open mic night. You're going to hear a judge calmly explain rights that most defendants would kill to fully understand, and you're going to watch this guy respond by calling her, and here's the twist: the judge isn't rude, she isn't reactive, and she doesn't raise her voice. Instead, she gives him every opportunity to protect himself, while he repeatedly steps on legal landmines like it's a sport. This is a masterclass in how not to behave in court, how quickly bond decisions can turn, and why judges care deeply about public safety, especially when family members are involved. Stick around, because by the end of this hearing, his own words may have cost him his freedom. Let's get into it.
Do that, so I would like to just voice that. Other than
We
that,
could
no
just
disrespect.
move
Yes,
forward, sir. Appreciate the.
correct.
Yeah, you'll talk
you.
about that with your attorney, absolutely. Okay, so, Mr. Mullins, I'm gonna stop the live stream so that I can protect your.
That he be given a low PR bond or a low cash surety bond, Your Honor. Thank you.
If it's
All
any
right,
money,
thank
I
you.
can't afford it. Let's just say that. I ain't got nothing, and y'all ain't give me any tools to get a job since I've been released from your guys' care. Now, I don't really know what's going on with my
Okay,
support
this
system, but
is,
it's
this
burnt
is
down
my
relationship
turn to
with my
talk,
family.
Mr. Mullins.
Metaphor.
Okay, you don't want to talk about that, because like I said, you're gonna, you might say something that can be used against you. So, the court's
Sounds
gonna
good.
look at two things, Mr. Mullins. I'm gonna look at whether or not you're a flight risk and whether or not you are a danger to the public. In regards to that, I'm going to look at your criminal history. I'm going to look at the allegations. I'm going to look at your ties to the community, your employment status. You live with your parents. I look at all of those to determine two things. I do have a concern for the safety of the public. On the matter that I arranged you on first, the arson, you are presumed innocent, but as I look at the allegations, it presents a concern to the court for the safety of you and any other individuals that reside in that location. I understand that would be
money.
that would be your parents.
1995.
Okay,
Trust me.
this is
It's all right.
this is my turn, sir. Okay,
I
so
bought it,
based
too.
on that, I'm not going to grant you a PR bond because I don't find that that is sufficient to ensure your appearance as well as protect the public, as specifically here your parents. The court is going to set a cash surety bond on that.
Right here is where reality should hit, but for this defendant, it clearly doesn't. The judge is laying out the charge in plain English: felony arson involving significant property damage. This isn't some paperwork technicality or misunderstanding. The numbers matter, the allegation matters, and the potential sentence absolutely matters. And notice how careful the judge is. She doesn't accuse him, she doesn't argue facts, she repeatedly emphasizes presumed innocent. That's not weakness, that's professionalism, but instead of absorbing the gravity of what's being said, he immediately pivots to his version of reality. This is a common courtroom mistake: defendants think they're defending themselves when they're actually digging holes. The judge isn't there to debate facts today. She's there to ensure rights are protected and procedures are followed. And do not violate any state or local laws while you're on bond. You're not to possess, purchase, or consume any alcohol or controlled substances without a prescription, and you're not to leave the state of Michigan without permission from the court. You also are not allowed to possess or purchase any firearms, ammunition, or dangerous weapons, and you will have to report to pretrial services so that they can set up any pretrial supervision that may be necessary. That's either a phone or an in-person interview. Now, I'm also going to tell you, you cannot have any contact with Daniel Mullins and or Barbara Mullins. You cannot call, write, page, email, text, no electronic communications of any kind. You can't have anybody else contact them on your behalf, and no threatening, harassing, or molesting behavior towards them or anyone else. Additionally, you cannot go within 2,000 feet of where where they're located at any time, including work, home, or school. So what that means is if you have property there, someone can go and get your property and get it for you, but you cannot go there and you can't have any contact at all. Also, you're unable to give me an address at this point
So if you are released, you have 24 hours to notify the public defender's office of the address where you're staying. If you don't do that within the 24 hours, the court then sets a bench warrant for you. Do you understand that? Do you understand what I'm telling you, Mr. Mullins?
And there it is, the moment where the tone officially goes sideways. Calling a judge, bro, isn't just disrespectful, it signals something much bigger, a refusal to recognize the authority of the court. Judges notice that immediately. Not because their ego is bruised, but because it tells them this person may not follow orders, conditions, or legal boundaries. The judge's response here is surgical. No yelling. No theatrics. Just a quiet, devastating reminder that understanding how old you are doesn't equal understanding how court works. That line, after 29 years you still don't get it, that's not sarcasm. That's concern. And if you're watching this thinking, wow, that escalated fast.
03520. Judge Simmons has ordered that you be remanded on that case file because you failed to appear for the probable cause conference. So you will not be released before that hearing that is to be set. Do you understand?
Yeah, y'all tweaking.
All right.
You guys know I have no clue what the hell y'all are doing. You have no details. You're making a bunch of judgments on very, 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 very misguided details. And the frail line understanding that you understand.
You're going to talk with your attorney.
What's the Rotary Club? Who am I? Do you guys know who I am? My name is Jacob Evan Mullins. You guys know who I am. That's crazy. You guys are playing silly ass games.
Did you have anything else?
I do not, Your Honor. Thank you.
Thank you.
And I am going to order a CMH evaluation on that new file as well.
I like that. That's about the one good thing you've done today, and it's not your fault. You're an amazing person, I'm sure. And I'm not trying to hurt your feelings or like I'm a frustrated individual. So let me just say, like, I'm sorry for the disrespect.
128-1837 counts 1 and 2. SP 156-07261. SP 162-4983. Counts 1, 2, and 3. SP 164-3083 counts 1 and counts 2 in the state of Michigan versus Elrico Gator, case number SX40380982. Appearance for the record, please, Mr. Barry.
Elwood S. Barry, Jr., on behalf of the defendant. State your full name, Mr. Gator.
I'm speaking for the corporation of Elrico Gator.
They're gonna love this one. Good morning to you, Mr. Gator.
Good morning.
All right, today is the date and time. So I kind of got to get an understanding of, we need Mr. Elrico Gator. We don't need the corporations of Elrico Gator. How do I have a driver's license suspended. I have a no insurance misdemeanor. I have a no ops. I have a failure to stop and an improper turn. So it should be 1, 2, 1, 2, 3, 4, 5, 6, 7, 8, 9 cases I called into the record.
Yes, Your Honor.
2 of them are civil infractions that were in default. I have no problem setting these defaults aside. They were kind of a little bit back in October, but since I just said it, I don't have a problem setting an improper left turn and a failure to signal at a stop sign or whatever that is, if the city has no objection to hearing these.
No objection, Your Honor.
Give Mr. Gator an updated offer. I also see a no insurance, the insurance no proof 288. If Mr. Gator is interested in getting a valid driver's license, he probably want to pay that 288. At least get a port of clearances here at 36 District Court. That's the only thing I can see affecting Mr. Gator's license. Mr. Gator, what I'm going to do is I'm going to put you in a breakout room with Mr. Barry. Have a conversation with him. Let us know what you want to do.
This section is crucial, and honestly, frustrating to watch. The judge carefully explains constitutional rights that generations of people have fought to protect. Right to remain silent. Right to counsel. Right to confront witnesses. And instead of simply saying, "Yes, I understand," the defendant latches onto one phrase and tries to spin it into some abstract philosophical objection. This is a classic tactic among defendants who believe legal language is negotiable. It's not. Courts operate on clarity and precision, not vibes and interpretations. The irony here is painful. The judge is actively trying to protect him from himself, while he keeps insisting on talking.
Case number 25 CRB 21. Mr. Corbin pled not guilty to one count of assault, a first-degree misdemeanor. In that case, on January 17th, 2025, this case is set for a first pretrial conference. 25 CRB 9. Mr. Corbin pled not guilty to one count of cruelty to companion animals, also a first-degree misdemeanor, on January 17th, 2025. 24 TRD 1. Mr. Corbin pled guilty to one count of no operator's license and not guilty to one count of expired plates, each of which are minor misdemeanor, and these cases are set, or this case is set for a pretrial conference and sentencing today. Those pleas were also entered on January 17th, 2025. There is a new case. The defendant was charged with and given a citation, an officer citation. And so this case, which is technically scheduled for tomorrow for an initial appearance hearing, we thought we would address this case today. In 25 CRB 23, Mr. Corbin was given a citation charging him with disorderly conduct, a minor misdemeanor. Mr. Corbin, did you receive a copy of that officer's citation, which was issued on January 18th, 2025? Mr. Corbin is present. He's accompanied by Attorney Philip Heasley. Also present is Law Director John Lewis. Mr. Heasley, your client has received a copy of the minor misdemeanor complaint of disorderly conduct. Does he wish to have his rights read, as well as a reading of the complaint?
Mr. Corbin, on this new charge. You have that right, sir.
Sure.
You have a right to be informed of and to understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with one count of disorderly conduct, a minor misdemeanor. If convicted of this offense, you face a maximum $150 fine and court costs. Mr. Corbin, you have three plea options. You can either plead guilty, not guilty, or no contest to this charge. So with respect to this charge of disorderly conduct, in the new case, 25 CRB 23, how do you plead?
Not guilty.
This is where things cross from awkward to dangerous, legally speaking. The defendant isn't just confused anymore, he's asserting beliefs that suggest he doesn't recognize the legitimacy of the process itself. Arbitration contracts, writing as art, settlement fantasies, none of that applies here. This is criminal court, not a negotiation table, and notice how the judge doesn't shut him down aggressively, she redirects him back to counsel.